Dan, I'm just going to introduce you and then let you take it. Okay, everyone, thanks a lot for staying with us after lunch. Really loved the comments as always. Clark Neely, so impassioned. And I had to say, Clark, you brought me back to so many conversations I had. I was at NFIB for 8 years, the National Federation of Independent Business. And I wrote a lot of amicus briefs, support of Paul's cases. You'll be hearing from Paul Sherman in a second, and a lot of other things. But a large part of what I did was I was talking to small business owners day in and day out about all sorts of regulatory issues. And you would think, they're running a business, they can afford a lawyer. And yeah, but no. I mean, the reality is they encounter so many legal issues day in and day out. And you just can't run to a lawyer for everything, and it's cost prohibitive. Even a lot of times, even for those small businesses. And I had so many conversations where we had conversations about the economics of litigation, and nonetheless, I had to always say, here's some general thoughts, and I could pass along a couple resources. But so often it was, but here's the state bar attorney referral service. Good luck. And that was always dissatisfying. That's part of why I went over to Pacific Legal Foundation, where I can be in the trenches and fighting, but we can't handle all these things either. Just one anecdote, because I always found this one a little bit amusing. So one of these many calls I had was an individual in Arizona, and God bless Arizona. We highlight Arizona very often in these series of white papers we've been doing in the state and local regulation working group. As an example, I mean, Arizona's done a lot of innovative regulatory reform things, and we certainly feature them quite a bit in this white paper we've been talking about today. But this individual ran a body shop for a car, and he said someone brought in his truck. And well, he couldn't pay immediately, so he was going to do a mechanics lien. He's going to hold on to the truck for a couple days until the guy came up with money. Well, a couple days go by, and the guy doesn't come back. And eventually, one of his employees says, "Can I take the truck for a second and move it?" So employee never came back. So he calls me, and he's concerned because he's suddenly now he's being charged for theft of this car. But that actually wasn't why he was calling. He was calling me to find out if he can still collect the fees that he was owed for the work he'd done in the car. So I think you got bigger issues on your plate. So in any event, that is day in, day out. People have issues. They need lawyers. And I'm really interested to hear what our Arizona folks have to say here about whether or not the reforms in Arizona are making a difference. And I want to hand things over to Dan Greenberg. Dan is with the Competitive Enterprise Institute, the general counsel over there. And he's been, in a lot of ways, my right-hand man for this entire project. So I appreciate him helping us move things along on this white paper and all sorts of other issues. So thanks a lot, Dan, and thanks for moderating.
So about 2 weeks ago, I was watching John Oliver's show Last Week Tonight, and I was intrigued to see that they had a 20-minute segment on the doctors board that regulates the practice of medicine across the state. And you will be unsurprised to hear about the subject of this segment, which is essentially that doctors do a terrible job of regulating their colleagues. And it seems likely that a lot of doctors who are supposed to be regulated by this board do commit malpractice invisibly, and they're essentially unregulated, unpunished by this board. And they had a segment interviewing one of the non-doctors, one of the civilians who was a member of this board, and you learn that he was stigmatized by the doctors on this board for doing essentially too good a job of keeping an eye on the doctors. And these sorts of stories of government malfunction, I think, are fairly familiar to us. I was watching this with my son, who's 18 years old, and I just saw his eyes got very wide, because to the extent he has political views, he has these sort of conventional public interest liberal views about how government always works to advance us and help us and so forth. And he looks at me, his eyes as big as saucers, and he says, "How does this happen?" And I said, "Look, I mean, if you really want to know the answer to that question, you should look. We got a book in the next room. We got the Federalist Papers. Look at Federalist 10 and Federalist 51, which are like the two best explanations of how this happens. And then my wife is also sitting there, and she says something that she often says to me before, which to paraphrase, which is like, some years ago she and I had this spirited discussion. Where it ended with her saying, look, when I ask you to go to the store and get a loaf of bread, this is actually not an invitation to have a discussion about optimal shopping theory, and she knows I have this kind of theoretical cast of mind, but I told him to go look at Federalist 10, Federalist 51, because I said, you can learn this, you can read this really fast, they're very short, you'll certainly shorter than watching this TV program. And he goes to the next room. He looks at Federalist 10, Federalist 51, and he says, this stuff is really good at explaining this is about the problem of faction, right? And I'm like, exactly. You've heard me talk about the problem of faction before. And he said, this stuff is really good at explaining the problem of faction, but his solutions are terrible. And I think there's something to that, because hundreds of years later, after we've all identified the problems of faction, we really don't have a strong grasp of the solutions to faction. We see, a very strong example of this is that we see our system of occupational licensing has these terrible and dysfunctional consequences, and that's just one facet of the problem of faction. And so today we have assembled 3 experts to do what James Madison could not do, and explain to us how we can really begin to address these problems of faction, which are by and large essentially in miniature they are the problems of lawyer licensing. And so today we have to discuss the practical challenges to legal licensing reform. We have Paul Sherman, who will tell us briefly about he will talk to us briefly about how he and IJ have worked to protect non-lawyers' rights to give legal advice. We have Caleb Trotter, who will talk to us about the challenges that are posed by such things as CLE requirements and interstate practices, and what I would call the meddling of state bar associations. And finally, we have Andy Kvesic, who will talk about the nature of the solution that they've begun to reach in Arizona, which is non-lawyer management of law firms, and what the implications of that are for ownership and management and profit seeking and so forth. So what I hope to do is allow all 3 of our panelists to give a brief opening statement, and then I hope we can have lots of crosstalk where we can question each other and go back and forth. And I hope we can also have, as we did before, have people come up to the microphones and help out and ask more questions. So I look forward to y'all doing your part to question each other, and I look forward to the audience doing its part to question us. So let me begin with Paul. Paul, we're pleased to have you here today. Paul's a senior attorney with IJ, with the Institute for Justice, and he's litigated in all sorts of areas, including First Amendment, economic liberty, property rights, and he has been the prime mover, and I think my favorite IJ case, in which he represented John Roseman, who was apparently hauled into court, or at least in jeopardy of action, largely because he was a successful newspaper columnist, in which he gave a sort of advice on how to live appropriately with one's family. He also represented Steve Cooksey in a First Amendment challenge to North Carolina's dietetics law, and he's litigated numerous campaign finance cases. So, Paul, we're pleased to have you here with us today. Tell us a little bit about your litigation experience and what you can tell us about the problems of faction, how to solve these problems.
Yeah, thank you, Daniel. So, the title of this program is "Does the World Need More Lawyers?" I think the answer to that is a qualified no, but it does need more people who can give legal advice. And this is something that Clark touched on in his keynote. Lots of people face common legal problems that don't require the services of a fully trained lawyer. You don't need the Cadillac of legal representation to deal with a lot of these things. And often you can get by a lot better if you just have a little bit of targeted advice from someone who's familiar with what's going on. But there's a problem, which is that state bars essentially universally have said that any kind of individualized legal advice is the practice of law, and you have to be a member of the bar to provide that advice. This is curious, I think, because advice is speech, and generally you don't need a license from the government in order to speak. And this strikes people when you say it as somewhat radical. Are you really saying that there's a First Amendment right to give legal advice without being a member of the bar? And in fact, that is exactly what I'm saying. And the Institute for Justice is currently litigating two cases, one that's before the Second Circuit Court of Appeals and one that's in the Eastern District of North Carolina, to vindicate the right of non-lawyers to give legal advice. So I want to briefly describe what those cases are about, and then I want to address some of the objections that we commonly hear, they may be occurring to you now, all of which I think are definitively foreclosed by binding Supreme Court precedent. So the first case is one called Upsolve versus James. We represent Upsolve, Inc., which is a nonprofit that wants to train non-lawyers to assist people in responding to consumer debt collection actions. A major problem with these lawsuits is that companies will buy up bad debt. Some of it is legally unenforceable, uncollectible, but they will file these lawsuits en masse, and people will default. They won't know how to respond to them, and then they end up owing money that legally they should not have to owe. Now, New York courts have responded to this by creating an answer form that non-lawyers can fill in on their own. But if you're unfamiliar with the legal process, it might be confusing, you might make mistakes. So Upsolve wants to train non-lawyers to assist people in filling out this form. We argue that giving people advice on any subject is protected by the First Amendment, and in fact, the Southern District of New York agreed and granted a preliminary injunction against New York's unauthorized practice of law statute as applied to Upsolve. And that case is currently on appeal to the Second Circuit. More recently, we have filed a challenge on behalf of a group called the North Carolina Justice for All Project and some of its individual members in North Carolina, challenging that state's prohibition on the unauthorized practice of law. And here, what the North Carolina Justice for All Project wants to do is assist people in filling out court-created legal forms for common legal issues. These are things like eviction, civil no contact orders, domestic violence restraining orders, uncontested divorces. Again, the court creates these forms for non-lawyers to fill in on their own. But if you're unfamiliar with the forms, you can make mistakes. And even if those mistakes don't prejudice your case permanently, they're mistakes that might slow down the resolution of your legal issue. And these people can benefit from having some guidance from someone who's filled out these forms before, which the North Carolina Justice for All Project's members, who are all state-certified paralegals, have done. So is this a radical idea, the idea that legal advice is speech? Not at all. And in fact, I think the contrary view, the idea that it is anything less than fully protected speech, is flatly foreclosed by binding Supreme Court precedent. How do we get to that conclusion? Well, for starters, there is a 2010 decision from the US Supreme Court called Holder versus Humanitarian Law Project that involved groups that wanted to give expert legal advice to designated terrorist organizations. And the federal government defended a law that prohibited them from doing that on the grounds that this was not speech. This was regulable conduct. And the Supreme Court unanimously rejected that argument. Now, ultimately, it upheld this prohibition, but it did so because it found that the government had satisfied its burden under the First Amendment. And so back around 2010, when this case was decided, Clark Neely and I were litigating a case involving interior designers in Florida, where we had this similar intuition that giving people aesthetic advice about interior design sure seems a lot like speech and should be protected by the First Amendment. Unfortunately, the Supreme Court had never addressed really this intersection between occupational licensing and the First Amendment. And lower courts had developed this body of doctrine called the professional speech doctrine. under which if you were engaged in a quote-unquote profession, however the courts viewed that, you didn't get the full protection of the First Amendment. But in 2018, in a case called National Institute of Family and Life Advocates versus Becerra, the Supreme Court rejected the professional speech doctrine. And it said that restrictions on so-called professional speech are treated the same way under the same ordinary First Amendment principles as any other restriction on fully protected speech. So great, we think we should be winning all of these cases, and the Institute for Justice has litigated cases involving occupational speech regulated by engineering boards, by boards of surveying, by state bars, by psychology boards, et cetera. And some of these cases we have won, and some of these cases we've lost. And so I want to talk just briefly about what I think is tripping up the courts that are getting these issues wrong and ruling against us. Because the legal argument really is this straightforward. Talking to people about any subject is speech. And if the government singles out that speech for regulation based on its subject matter, that's a content-based regulation of speech subject to strict scrutiny. And if the government can't satisfy that scrutiny, it's unconstitutional. So how are courts messing this up? The biggest way they're messing it up is this distinction between speech and professional conduct. And what a lot of lower courts are doing is saying when you give someone legal advice, that's not actually speech, that's the conduct of practicing law. Or if you give someone medical advice, or if you engage in talk therapy, that's not speech, that's the conduct of practicing medicine or the conduct of practicing psychology. But in fact, the Supreme Court has an answer to this, and it comes again from Holder versus Humanitarian Law Project. And that case holds that even when a law can generally be regarded as being aimed at conduct, such as the conduct of practicing law, when an application of that law turns on speech containing a particular message, that application has to satisfy the First Amendment. So in Holder, the example was a federal law that prohibited giving material support to terrorist groups. What the court said is, here, that's being applied to expert advice about their legal rights. If this group wanted to give advice about something else, like general advice, that wouldn't be regulated because they want to give specific advice. It is regulated. Therefore, this is a regulation of speech as applied. It's not a regulation of conduct. The next thing that trips courts up is this idea between regulations that are content-based and regulations that are content-neutral. And a lot of courts look at things like the regulation of legal advice, and they say, well, this is a content-neutral regulation because we don't actually care what advice you're giving. We don't care if you say that you should settle this case or you shouldn't settle this case, whatever. We just care that you're talking about law. This argument, too, is flatly foreclosed by Supreme Court precedent because the Supreme Court has made clear that it conflates two types of speech, or two types of speech regulations. One is viewpoint-based regulations. That's speech that, those are regulations that turn on the viewpoint being expressed, and those are essentially per se unconstitutional. But the Supreme Court has also said that regulations that single out speech based on its subject matter are themselves content-based regulations of speech and subject to strict scrutiny. And of course, that's what these occupational regulations are. I can give someone advice on anything under the sun, but if I give them advice on something related to their legal rights, that's considered the practice of law and subject to additional regulation. And that is a content-based regulation. Courts sometimes get confused about the notion that, well, people are getting paid for this advice. And so if you're getting paid, that's not as protected as if you're giving the information away for free. Flatly foreclosed by Supreme Court precedent. The Supreme Court has repeatedly held that the fact that you get paid for your speech has no bearing on the level of First Amendment protection. Well, maybe it makes a difference that the government isn't banning this speech, it's just requiring you to get a license. Well, first of all, generally you don't need to get a license from the government in order to talk about anything. But second, the court has also said that content-based burdens on speech are subject to the same standard of scrutiny as content-based bans on speech. So it simply doesn't matter that the government hasn't proscribed the speech entirely. when you look at all of these things together, you find that all of these common objections, these intuitions that people have, they can't be squared with the Supreme Court's precedent. So what is driving this? Well, I think that a lot of judges are resistant to this conclusion because they are afraid of what the implications are going to be. Does this mean that we simply can't regulate the practice of law at all? And no, it doesn't mean that. Or does this mean, even outside the practice of law, does this mean we can't regulate the practice of medicine? No, it doesn't mean that at all. First, there is the distinction between speech and conduct. Now, when lawyers give advice, or when anyone gives advice, that is speech. And if the government regulates your speech, it has to satisfy the First Amendment. But there's a lot of things that lawyers do that either aren't speech or aren't fully protected speech. So, for example, appearing in court. Court is not a public forum. It is a government-created forum where the government has historically greater power to regulate who can appear in it. Lawyers often act as agents for their clients. They make representations that can bind their clients. Lawyers handle client funds. These are all things that either aren't fully protected speech or simply aren't speech at all, and the government can regulate those things without offending the First Amendment. Traditional consumer protection laws, laws against fraud or false advertising, similarly, are not affected by this legal theory. Fraud is not protected by the First Amendment. False commercial speech, misdescribing your credentials is not protected by the First Amendment. If I go out and say that I'm a member of the bar of a state that I'm not a member of, the government can punish me for that without offending the First Amendment. And finally, some people are very concerned that does this mean that you can't regulate malpractice? I don't think it means that at all. First of all, the Supreme Court in the Nifla v. Becerra case specifically identified malpractice laws as laws that don't offend the First Amendment. But also, there's a strong argument that malpractice laws for both law and medicine, at least when applied to information that has created real harm, are a historical exception to the First Amendment. In a case called United States versus Stevens, the Supreme Court held that the way we identify historical exceptions to the First Amendment, things like defamation, fighting words, fraud, is that we look at the history to see, have these historically been treated as unprotected? And both medical malpractice and legal malpractice are causes of actions that predate the enactment of the First Amendment. So what does all of this mean? The government has lots of regulatory tools at its disposal for dealing with the real concerns that people are going to get bad or incompetent legal advice or that people are going to misrepresent their credentials. But as for pure advice, the rule should be that we regulate it the same way we regulate books of legal advice. And, Lucian in the last panel talked about the How to Avoid Probate book and the case from the 1960s. It sounds ludicrous today to think that the government could punish someone for writing a book about a legal issue. And I think if you asked essentially any federal judge in the country, they would agree that there's no way you can regulate a book about those kinds of legal issues. Well, the exact same rules should apply to individualized advice about legal issues. And there is no principle in First Amendment law that allows for a distinction between the way we regulate books and the way we regulate that kind of one-on-one advice. So that is what we are trying to do with this litigation, and I look forward to answering questions about it.
Thank you. Caleb, I want to ask you to speak in just a moment, but before we do that, Paul, can I ask you a quick question about how to best understand the speech-conduct distinction? If speech is speech that's part of a technological or causal system best understood as speech or conduct, and by that I mean, say, let's say I have a light switch that's activated by my voice, or say, to be a bit more imaginary, if I have a car that's affected by my verbal commands, for instance. Mm-hmm. Is that appropriately understood as conduct and fully regulable, or in your view, is that completely speech?
So I think that's a great question. I think in that situation, the Supreme Court's test would probably treat that as conduct. If I can make an analogy to popular culture, think about Harry Potter, right? In Harry Potter, there are magic words. And if you point a wand at someone and say, Avada Kedavra, right, that kills them. Now, Avada Kedavra, definitely words, but if the government regulates that, it's not regulating the message you're communicating. It's regulating the non-communicative effect of saying those words. And if it's regulating turning on a car, that would be an example. Maybe a more down-to-earth example, not quite so magical, is a doctor's prescription, right? The recommendation that someone take medicine is fully protected speech. A doctor's prescription, even though carried out through the written word, creates a legal entitlement to access a controlled substance. And so when the government regulates who can write prescriptions, what it's regulating is who can create those legal entitlements, not who can recommend that you take certain medication.
Thank you. So Caleb, thank you also for appearing today. Caleb Trotter is an attorney at the Pacific Legal Foundation, where he litigates on behalf of individuals and small businesses fighting for their constitutional rights to free speech and economic liberty and equal protection under the law. Caleb's practice is primarily focused on free speech rights that allow people to pursue the profession of their choice in the manner they see fit. He's represented Peggy Fontenot on in her challenge to an Oklahoma law that prevented her from truthfully representing her art as American Indian made. And he's also taken the lead in fighting for male students who want to participate in athletics that are free from sex-based quotas. He successfully represented several male students who wanted to challenge rules in Minnesota and South Dakota that prohibited them from participating in high school competitive dance teams. Caleb, tell us a little bit about your threefold subject for today, which I already talked about. What would you like to tell us about today?
Thanks, Dan. So earlier today, we've heard about different alternative ideas for lawyer licensing and opening up access. But in my, and I'm sure many of your experiences, there are some peripheral issues to attorney licensing that when you add them all up, create themselves significant burdens on the legal profession and access at affordable rates. And specifically, I'm going to touch on continuing legal education, or CLE, local court rules, and just kind of in general, the interstate practice of law. And as Dan said, I'm an attorney at PLF, and being a public interest civil rights lawyer, that effectively means that I have a national practice. Many of you can say the same things, but of course we don't all have a license in all 50 states. That would just be ridiculous for obvious reasons. But I think there are a number of ways that even with having only one or very few licenses, that courts and bar associations, legislatures could still make access to various forums and states much more accessible and lower the burdens to legal services. And so starting with CLE, I don't know about you all, but other than Federalist Society events, I typically find that most CLE courses are just a complete waste of time and money.
Except this one.
Are we getting CLE for this one? I don't know. But the idea behind CLE that we're staying abreast of developments in the law, that's a sound logical basis. But the way that most states, in my knowledge, implement CLE requirements, they just widely miss that mark completely. I'm in California. I'm licensed only in California. Our CLE requirements are we have to have 25 credit hours every 3 years. Within that 25 hours, 4 of those must cover legal ethics, okay? 2 of those must deal with various forms of bias, 1 including implicit bias. And then 2 have to involve various competence issues tied to concerns around substance abuse or mental health. Now, but every other credit within that 25 are entirely up to each individual attorney. They could be 100% relevant to your practice. They could have absolutely nothing to do with your practice. You might be interested in the topic. You might not. It just doesn't matter. You just have to show that you've educated yourself. Well, you kind of have to show that. You just attest that you've done that, and maybe you'll be one of the unlucky few to be audited by the bar to just make sure you did that. It's never happened to me or anybody else I know, but I assume they're doing that. But so the way that has worked in practice for me is what I can't get in CLE credits through FedSoc events or other things that are actually relevant and really interesting to my practice or areas that I would be interested in looking into is when it's coming close to the deadline every 3 years, I just buy the cheapest package I can get that allows me to power through them all online in the quickest amount of time while paying the least amount of attention I possibly can. Now, I don't think that serves us as attorneys. It certainly doesn't serve the public. All it serves is the CLE industry, but it's certainly in no way ensuring competence or quality legal representation. Now, in contrast, as I'm sure a lot of you have, I have dozens of alerts on Westlaw, Google, Court Listener, even various state legislatures around the country that will let me know immediately as soon as a case or an issue or even a pending bill that's relevant to my practice. Those alerts let me know immediately when something is coming up that's relevant to that. And that helps me keep up on the state of the law as well as any issues that might be percolating locally that might become an area of practice or a case for myself. And so what I'm getting at here is if the real concern is just to ensure the competence of attorneys and state bars don't trust us to do that ourselves, there are plenty of easier and cheaper ways of doing that that focus in on what an attorney is actually doing and should remain competent on. As Braden said earlier, if somebody asked him to do a will, that just would not go well. I actually did kind of look at that for some family and quickly realized I didn't know what I was doing. I didn't want to risk it, and I also just didn't want to deal with, assisting family with legal matters. I'm sure you all have wondered about before. But so, now all that being said, and as annoying as CLE requirements may be, I think it's probably unlikely at best that CLE is limiting the number of practicing attorneys in the United States, but it's not nothing. If it weren't for Louisiana's CLE requirements, I would be licensed in that state as well. I went to law school in Louisiana. I lived in Louisiana a long time. I even studied the civil code system in Louisiana, so everything I know about common law contracts and property law, I learned entirely in bar prep for the California bar exam. That's maybe why I don't work in PLS property rights group, but nevertheless, the problem is that not that Louisiana has CLE, as every state I think does. The problem in Louisiana is a majority of their hours, which you have to report every year, have to be taken through in-person classes that are pre-approved, and surprise, surprise, most all of those are held in Louisiana. Maybe occasionally there's a 4-hour course in San Francisco or something that I could drive over to for the day, but to date, I just haven't been able to justify the time or the expense to be able to comply with that, to become licensed in Louisiana, and sometimes that matters. Like I said, PLF and other civil rights lawyers, we have national practices. We, fairly regularly, we occasionally have cases that come up in Louisiana, and being able to avoid having to go find and identify a local counsel can be really helpful. It can speed things along. But because of those requirements, I'm just not able to be licensed in Louisiana for now. There's also a growing concern about politicizing CLE. And I mentioned earlier that California requires CLE that includes implicit bias. And I don't know if you know much about implicit bias, but it's a highly controversial topic that many people are skeptical of the very notion of the existence of subconscious bias. But nevertheless, we have to take a course on that. Fortunately for lawyers, it's even worse in the medical field in California. So physicians in California have to take 50 hours of MCE every 2 years. And as of last year, basically all 50 of those hours must include a component on implicit bias. Now that requirement is so extreme that PLF is currently challenging the constitutionality of that on behalf of MCE instructors. But there are also requirements in California like cultural competency that are spreading through various medical fields, and some of them are even beginning to include and require training on various gender and sexuality based identities. Clearly these are controversial ideas, and I expect that we're only at the beginning though of these requirements starting to spread throughout not just the medical industry, but I think it's only a matter of time until they find their way into the legal field as well. And so, I also don't think that it's outside the realm of possibility that eventually some attorneys might start declining to renew licenses, especially in secondary licensure states where it's not their primary license. But if they have to deal with not just the hassle and the expense of CLE generally, but if they start being required to attend things that are either extremely controversial or even in some cases offensive and that violate their beliefs, just why bother? And so you could see just a lessening of the amount of available attorneys in a given state, and you could also see a problem of lessening viewpoint diversity among attorneys in states like this. So there's some issues I see with CLE. And then with court rules, local courts, in addition to CLE, place their own barriers on legal practice. The vast majority of my practice is in federal court. I think I've only ever had 3 cases in a state court. My very first one, I wish Braden was still here, my very first one was an amicus brief in one of Braden's cases out of Nashville. But so my comments here will focus on federal practice. And so I'm sure most of you are aware of what's called pro hoc vice admission. That's where you're essentially admitted by the court for the purpose of just that one case. And that's basically how civil rights attorneys are able to have a national practice and practice wherever the case may take us, regardless of our licensure status. But the only catch is nearly all courts require you to be sponsored by a local attorney who's licensed in that jurisdiction to, in essence, supervise you to make sure that you're not, acting poorly as an out-of-state attorney who doesn't know anything. I guess it's a way to avoid carpetbagging or something. But many of the rules explain that the reason for this is that the court and opposing counsel need to be able to just easily get a hold of you when anything may come up in the case. And while I don't think that's ever necessarily been a good enough reason, but it's certainly not a good enough reason in 2024 where basically all federal court filings are required to be electronically filed. Virtually all communications between counsel is done via email, occasionally a phone call. Even meet and confers between counsel are done over phone, or these days a lot of them are done by Zoom. And more hearings in court themselves are being held remotely. So this idea that we can have and rely on the phone and electronic communication for everything else about a case, but if the court or opposing counsel needs to contact you, it would have to first go through somebody in state or in town that they're also going to use that same mechanism to get in touch with. It just doesn't make sense. But it's also unevenly applied. For example, PLF recently filed a case in Montana. The PLF attorney who filed the complaint, he lives in Utah, but he's licensed in Montana. So no truly local counsel was necessary to get that case going. But because Montana's local rules in the district court require an attorney who sponsors another attorney for pro hoc vice admission, that attorney has to have a physical office in Montana. I wish I could say that that was just an outdated rule, but apparently that rule change took place like a year and a half ago. I would be interested to hear why. But in any event, fortunately we have groups like Federalist Society and American Jurors Link who help us when we do need local counsel in various states, but it can be unnecessarily complicated and it can cause delays. Sometimes there's a real difficulty in finding someone, especially if it's a hot button issue or controversial, or maybe you want to challenge a Republican official and all of the people on FedSoc's list don't want to be involved with a case challenging a friendly governor or something like that. So sometimes it's a lot more difficult than you would think it is. But in any event, it really just winds up overstaffing a case by having more attorneys than you need, which can increase time delays as well as cost in litigating a case. And think about it this way. My colleague who lives in Utah but is licensed in Montana, he could have been on that case all by himself, regardless of the rules, just because he's admitted there. But is there any difference in these being able to access you easily rules between him being in Utah versus me being in California? I don't think his bar status magically makes a change there. And so So I don't really think there's a good principle in creating these local attorney requirements that just complicate and create delays usually in legal practice. And so really what I've talked about so far are just highlighting some of the issues that arise with the interstate practice of law. So is there an easy solution? I think earlier there was some conversation about, a universal law license. Well, what about a federal universal law license? I don't really want to take any other bar exams or get other bar licenses and have to keep up with yet more CLE, more fees. So what about universal reciprocity amongst all the federal district courts? That's basically what we already have in the courts of appeals. I think I'm admitted in about half of them. You just have to show that you're admitted in one, pay the fee, certificate of good standing, and you're off and running. So why couldn't we have this in the federal district courts as well? It would essentially work like pro hoc vice. You just cut out the local counsel requirement. And if there are issues with that, we already have a duty to be up to date and be familiar with the court's local rules. If there are any true concerns about local practice or special situations that are unique to a local jurisdiction, you can always look up templates from filings that have been made, not just on PACER, but there are other free ways of doing that. And if you really have a situation where this is complex, it's complicated, I might really need to consult with somebody, then you're already going to do that. The local rule requiring you to associate with someone locally isn't what's causing that consultation. I would also liken federal legal practice to medicine. At least in the United States, physician licensure is substantively identical, more or less, in all the 50 states. That a physician would need a license in every state she practices would be very unduly burdensome, and it wouldn't have a corresponding public health benefit to counteract those burdens. That's why PLF is currently challenging New Jersey's rules in the context of out-of-state physician specialists who are just seeking to consult with patients via telehealth. New Jersey requires you to be licensed in the state, and so this affects experts at renowned name brand hospitals. These are the doctors you go see when your local physicians don't have the resources or the expertise. But those specialists, while they could reasonably see throughout the course of their career patients from all across the country and around the world, they're not going to get licensed in all 50 states. They've done the math, and it would cost just up front about $90,000 in fees alone to do that. Fortunately, it's not as bad as that for us attorneys because of pro hoc vice rules. But when you add up CLE, the restrictive local counsel requirements, it just starts to add up, and it generally makes things more costly, more time-consuming, more resource-intensive when it doesn't have to be that way. So to sum it all up, does the world need more lawyers? I don't know, but maybe if we could make it easier for the existing lawyers we do have to better serve their clients around the country, regardless of where the client is, regardless of where the attorney is licensed, then maybe we wouldn't. And I'll leave it at that, Dan.
Thanks very much. Our third speaker today, Andy Kvesic, is now managing partner of Radix law firm, following an extensive legal career in complex business litigation for nearly 10 years. He then became a prosecutor with the Arizona Attorney General's office, and after that he was appointed chief counsel and legal division director of the Arizona Corporation Commission. And today he's going to talk to us about some, I think, unique legal issues having to do with Arizona's experiment in private ownership of law firms and the implications thereof. Andy, tell us a bit about that.
Thank you, Daniel. There's been a lot of talk about alternative business structures today, so I just want to set the record straight. And just so you know that I'm not a critic that's just been examining this from afar, not only do I run an alternative business structure, I've helped a dozen or more clients through the process. I'm on the committee that approves the applications. I'm on subcommittees and task forces examining this. So I've got a ground level understanding of what's really happening in Arizona. So taking a step back, in 2021, the Arizona Supreme Court made significant changes to lawyer licensing rules in Arizona. They did two things. The first was the court eliminated our version of Model Rule 5.4, the fee sharing rule that says you can't share fees with non-lawyers. Our Supreme Court just deleted that rule. So in Arizona, if you're an Arizona attorney, you can share fees with non-lawyers. You don't have to be on the case. You don't even have to tell your clients about it. You can just share fees with non-lawyers. The other thing the court did was they created the Alternative Business Structure Program, the ABS program. And effectively, what an ABS is it's a business entity where non-lawyers have an economic interest or day-to-day decision-making authority, but that also provides legal services. Okay, it's not a place where non-lawyers can provide the legal services. At the end of the day, ABSs are all law firms. And so why did the Arizona Supreme Court do this? They did it for a lot of the reasons that we touched on today. They felt that this was a way to increase access to justice and increase access to legal services. The court wanted to promote innovation in the practice of law. They wanted to provide a mechanism to create a more diverse legal profession. There was a belief that, this program could create one-stop shops for professional services, multiple professional services. And there was also belief that, hey, this might be a good way to provide private capital for law firms to, have them function as a better business and be more financially stable. And so in the spirit of this part of the program, the challenges in legal licensing reform, you could talk about what it takes to become an ABS. It's not easy. There is an extensive application process. There is an ABS. There's an ABS staff that does background checks on everyone. It's a lot like going through character and fitness. And what the ABS staff and what the application requires you to disclose is who owns 10% or more and or who has day-to-day management authority, whether that person is a lawyer or a non-lawyer. The application also requires you to disclose who your compliance lawyer is. And so the qualifications for a compliance lawyer to be an ABS is that you can't just be an Arizona attorney that just got your license. You have to establish that you're qualified, that you've run a law firm before, that you understand the rules of ethics, that you understand how to run a trust account, because you will effectively be the internal cop for the organization to make sure that the ABS is running properly and following all the rules of professional ethics. And if the ABS is not, it's the compliance lawyer that then has to answer to the Supreme Court. And so this is the first time in our profession where at most Supreme Courts across the country govern lawyers and not law firms. So in Arizona, we now have a mechanism where the Supreme Court is actually regulating law firms. And so I think it's important to note the types of entities that have been approved and sort of how the program has evolved over time. There's about 60 licensees that have been approved. There's another 30 or so that are in the pipeline. The way it works is you submit your application, the ABS staff then does their background checks, which is now taking up to 6 months. The ABS staff then makes a recommendation to the ABS committee, which I'm on. The committee is comprised of lawyers, non-lawyers, retired judges, active judges. So we look at these applications and then we make a recommendation to the Supreme Court. But ultimately, it's the Supreme Court that says yes or no based on the recommendations that are sent up. And so to date, you've had everything from small firms where a tax attorney teams up with a CPA and they create an ABS. Or I had a client that provided immigration services that was going to team up with a relocation and language service. And so you weren't just going to become a citizen, they were going to help integrate you into society. There's a really cool model. It was a patent lawyer and a venture capital firm, where if you're a garage inventor and you have this idea for an invention, you could go to a patent attorney, and then the venture capital firm is going to fund that patent and then help you go to market with it. So there's a lot of really innovative ideas that have now come into existence because of the ABS program. Out of the 60 or so applicants, more than half of them are personal injury, mass tort, class action firms on the plaintiff side that have teamed up with private equity, so they have an additional source of capital to pursue, kind of those bigger, more expensive cases. But I will say, if the question is, how is it going? And the gloves came off earlier this morning when someone said that there's zero evidence that this is helping anyone. That's just wrong. And I think it's a little dangerous to go in, forums like this and say things like that. It is actually helping a lot of people. And if you think about what access to justice means, it doesn't just mean helping poor people afford lawyers, okay? Rich people use talcum powder too. Rich people, have babies that drank formula and the babies ended up getting cancer. And so if you're creating an environment where you're modifying the licensing requirements for lawyers, and it's allowing clients to get access to justice and access to attorneys and pursue cases that they otherwise could not afford, that's a really good thing. Access to justice also means things like at my firm, where my non-lawyer owners don't even have keys to the office. Okay, despite what was said, they don't sit next to me at the end of the year and then tell me what the distribution should be when we have a profit. What they do is when we're putting together a budget, and I've got a business partner that's a CEO of a publicly traded corporation, and a business partner that's running their own construction company, and a business partner that's a CPA running an accounting firm. And they can actually provide me some real-world business advice that lawyers just don't understand, despite how smart we think we are. They can help me decide how to deploy our capital and where to spend our marketing dollars and where to grow the firm. There's a ton of value in the lawyers just being able to practice law and not having to worry about those things, like what kind of software should we use, or what are we going to do with our excess proceeds this year. And so I use them as a board of advisors, but they don't even come into the office. They don't even have keys to my office. They don't know who our clients are. And so I just want to dispel this notion that, like, just because you have an ABS doesn't mean there's a non-lawyer in there that's calling the shots and telling you how to represent clients. So there are a ton of really, really good things happening in Arizona. But like any new program that's revolutionary like this, and in our profession, if you think about how old the legal profession is, it's older than this country. We've never really had a revolution, so to speak, and I think that's why you get a lot of pushback from traditional lawyers and traditional law firms. It's just, we don't like it because it's different. And I can remember a time when, well, probably wasn't when I was alive, but law firms used to all be general partnerships. And there came a time when they were allowed to be limited liability partnerships. And a lot of people thought, well, oh my gosh, that's going to totally change the way attorneys represent their clients. If they have limited liability, they're just going to start practicing law like a bunch of cowboys because there won't be any consequences. Well, you'd be hard-pressed to find any firm in the country right now that's a general partnership. Everyone is some limited partnership type structure. So, there will be critics, and I'm not saying that this program needs to exist everywhere, but I'm in favor of any program that increases access to justice, that allows lawyers to be more productive, spend more time on their clients, that just fixes a lot of things that are wrong with our profession. And I think, the ABS and the licensing reform issues that are going on in Arizona have really, achieved a lot of the goals that the court hoped it would.
Thank you. So I was quite struck by the way Paul began his presentation by asking, do we really need more lawyers, or is it that we need more legal representation? And I'd like to respond to that with a question of my own for the panel, which is what is important about having lawyers, or is what is important about having legal representation, is that we have fiduciaries that we can rely on. How do we best understand the role of fiduciaries in the legal profession, and in particular, when we're looking to provide more legal representation? Are we really looking for more people that we can trust with our problems? Certainly, there are many fields that we have certain provisions for certain kinds of fiduciary responsibilities, or things like fiduciary responsibilities. For instance, we have banks with deposit insurance, and we have construction endeavors with bonding programs. And it seems to me that when we hire a lawyer, we're giving that lawyer our trust, and we're giving him often something that's very valuable, and we need to have a way to make sure that our lawyer or our legal representation can be trusted to handle the valuable thing that we're giving him or her in a responsible way. And so when we talk about regulatory reform of the legal profession, are we talking about something importantly that addresses this problem of fiduciary responsibility, or are we talking about something else? That's my first question for the panel.
Yeah, so, the professional speech doctrine itself, when it existed, was kind of rooted in this idea that when you take someone's affairs personally in hand and you are exercising judgment on their behalf, that you are acting in a fiduciary capacity. And so the government has a stronger interest in regulating that. I think that's probably correct. I think the mistake that courts made was to assume that that means that if you are giving someone advice, the First Amendment doesn't apply. I think this goes to the strength of the government's interest under the First Amendment, but it can't be a substitute for First Amendment analysis, at least when you're talking about legal services in the form of pure advice. But the other thing I would say is that obviously, there are lots of situations where you want to be certain that the person you are getting advice from is a fiduciary. But this is not just about the right of the speakers being lawyers. This is about the right of clients, of listeners, to seek out advice from the sources that they trust. And some people may be willing to say, you know what, I'm not so interested in you having a fiduciary duty to me that's established by law, but I trust you. And this is how people decide who to listen to when they pick out books, or when they, go to forums online or go to Reddit and they start asking questions. They put an inquiry out, they get information, and then they decide for themselves whether that information is worth listening to. So I certainly think there is room for the government to establish these kind of fiduciary relationships, but they can't escape First Amendment scrutiny, at least when it concerns pure advice.
I guess I would just add to that the license itself isn't and maybe even shouldn't be what creates the fiduciary relationship. I think that can be separated from licensure. I think it was alluded to earlier that even though us attorneys are licensed to practice any and all manner of law on any topic, assuming that we're adhering to our duty of competence, I wouldn't trust myself to do virtually anything that's not in my core competencies, which is extremely narrow. Whereas if someone had devoted training to a discrete field, whether they're an attorney or not, I don't see why you couldn't create a fiduciary relationship for something like that. It's not the license, it's the fiduciary relationship that's important there, and I think you can create that through any number of ways.
Yeah, I always chuckle when I see law firms promote that they're client-centric, because I read that and I think, well, I hope so, because that's what the ethical rules require you to be. And so, but financial advisors like to throw around the word fiduciary a lot too, because it sounds sexy. But in reality, yes, you have to have your client's best interests in mind. And so I'm okay with if you're bringing in non-lawyers into the profession to contribute. I'm okay with holding them to that higher standard. But at the same time, I don't want there to be there seems like there's some notion that if you're not a lawyer, you're somehow inferior, intellectually or ethically, and that's just not the case. And so you sort of have to keep that in mind, that they're not bad people. It's not the equivalent of letting a bunch of gangsters into our profession. And so, should everyone be held to that standard if you're practicing law representing clients? Yeah, I think that's a good thing for us.
I want to follow up on that just a little bit, because it seems to me that a law license does seem to be something of a proxy for some sort of fiduciary liability, right? And I think that there are two implications of that. Some of the conversation that I've heard earlier today suggests that it would be perfectly appropriate to have paraprofessionals or different types of people who specialized in what I would call low stakes legal disputes be empowered to handle them. And I wonder if that suggests that what we're talking about in the ideal world is that we have different kinds of professionals with essentially different implied levels of fiduciary responsibility. I mean, if you trust somebody to handle a case for you, and the worst thing that happens is you might get hit with a $50 cash fine, that's kind of low stakes, and you can understand how you might want to have an institution that would allow more representation by non-lawyers to come in there. But I guess my sort of to follow up on that, is there a way that we can have some sort of fiduciary liability for legal representation without a license? Because, I mean, it seems to me the upshot of this is that the institution of law licenses, or something very much like the institution of law licenses, is really necessary for people to feel comfortable about depending on a professional. Is that right? I mean, do we have to have a law license in medium stakes cases and high stakes cases? Is that socially necessary?
So I have a couple thoughts on that. I think number one, the notion that we could have some more limited licensing for people to handle lower stakes cases is itself evidence that there are less burdensome alternatives to the regulatory system that we currently have. And at least under the First Amendment, that's a critical question, because when courts apply strict scrutiny, they have to show, or the government has to show, that it has regulated speech in the narrowest possible way, and that it has burdened it to the smallest extent necessary to achieve its regulatory interest. I think that's one aspect of it. I don't think that it is necessary that the government require everybody who gives this advice be fiduciaries. But what I do think they could do is create voluntary systems of certification or registration so that people can advertise to the public, I meet certain, maybe minimum standards of experience and education, and I am willing to be bound by this regulatory system where you are going to have certain recourses against me if I don't live up to the ethical standards of my private certification. And this is almost what North Carolina has and was kind of moving towards with regard to paralegals, because North Carolina has a system of paralegal certification through the state bar. It's a totally voluntary system. You don't need to be certified in order to act as a paralegal, but it's a way for paralegals to advertise to potential employers and to the public, hey, I meet these minimum standards. And you could certainly see a limited licensing scheme that was based around that kind of voluntary certification.
And I can provide just a data point in terms of Arizona where we have created, it's called the Legal Paraprofessional Program, where paralegals can, in some instances, go into court and represent clients. The genesis of that in Arizona was in family court, where there's just a huge docket of cases. There's so much volume. The cases are messy, and they get even messier when unrepresented litigants who are in the middle of a divorce, are just, it drives the judges crazy. So the judges there really like it, because now you can have a paralegal come in what is a form-heavy practice. I think there's not a ton to litigate in a divorce proceeding. I mean, there's custody issues, and I don't practice family law, but there's not a huge advantage to having like a really savvy, divorce attorney, unless you're trying to take your ex's organs or something like that. But the routine divorce, it's the way it's shaken out in Arizona is it's really cleaned up the dockets a lot. The judges like it. It streamlines the cases. People are, again, going back to access to justice, people are able to get their disputes resolved more quickly. And so I think licensing is a good thing for that, because it ensures those paralegals or those paraprofessionals are trained in that family law expertise. The flip side of that is if those of you who are attorneys that practiced at firms and larger firms probably understand that there was always that one paralegal when you first started. There was always that one paralegal that really knew everything and that knew more than you did. And the way to succeed is you would develop a relationship with that paralegal, because he or she would basically tell you how to do everything and where the forms were. And so that person may or may not have been a certified paralegal, but they had a ton of experience. And at that moment, they were smarter than the licensed attorney. So, there's a point to be made that you really need to show someone passed the test, or if they just have the experience, is that good enough?
Caleb, one very provocative part of your presentation was about certain controversial CLE requirements. I was thinking particularly, I guess I don't know quite how to put it. I guess I would say I'm intrigued by the notion that it's necessary to train all lawyers in the state in implicit bias theory. Are there avenues to challenge these kinds of provisions outside of removing CLE entirely?
It's tough, Dan. So our case in the medical context right now, that's solely an as-applied challenge to instructors because they are being compelled to include discussion regardless of the topic that they otherwise would choose not to. It's very different versus California's attorney requirement, which is take a course on implicit bias. You sit there from an instructor who's presumably very interested in that topic, and you listen or not to whatever. But it's very different if all instructors, regardless of what they're teaching, are required to include that. It's a compelled speech problem. So I think it would depend on what the requirement is. If the complaint really is just, I don't want to have to take a course like that because I don't like it, I disagree with it, I believe differently, then it gets tricky. There was a week or two ago a case out of the 8th Circuit basically involving like workplace diversity training requirements, and even Judge Strauss was on this panel, and they agreed that that's not a compelled speech problem for the listener because it was just watch these videos, you have to do it for your job, and then go about your day. The situation would change, I think, tremendously if the attendees for such a course were required to start, affirmatively attesting to certain things on any manner of controversial topics, or just things like of that nature. So I think there is potentially a kind of compelled listening claim, as you will, but I think you're going to have some pretty egregious facts to get a court to get over the fact that you just don't want to sit there and listen to it. And in our First Amendment tradition of protecting, very offensive speech, just get over it. So if the complaint is on listening, then it's going to be tricky. But like I said earlier, I think that we're really just at the beginning of seeing controversial topics like this begin to be required in law and of course, medicine.
So before I ask this next question, I want to underscore, I'm happy to sit up here and pose questions to the panelists all day, but we do have microphones up here, and I hope that if other people have questions that are prompted by this, please come up. And in fact, I see someone there at the microphone. Please do ask your question.
Yes, on the subject of the continuing legal education and implicit bias, so is this an opening for conservatives? I'm not sure if the Federalist Society could fit it, but a course along the lines of two views of implicit bias. So you could, obviously, there's an effort at indoctrination in the course. So you could have counter-indoctrination at the same time. Could that be an answer to that problem, not just for legal education, but in the workplace? A lot of times those courses are all, they're bought from other places, and that could be the next movement for Vivek Ramaswamy or somebody to pursue.
I think the answer is just it depends on how the requirement is worded. I think California's CLE implicit bias requirement is pretty broad and perhaps even counter-programming, just contesting the validity between the IAT test, which is kind of the basis for implicit bias, which essentially just measures the time it takes you to click your mouse in response to certain pictures. I think it's roundly been debunked, but it's still relied on for these trainings. But I think there's room within the way that requirement is written where you could just have a course debating the merits of it generally. But at least in the medical context in California, you wouldn't have that option, because the way the legislature created that It's you must, the instructor, include examples of or strategies to combat how a disproportionate care resulted from your implicit biases. So that requirement is from the beginning set up from a particular viewpoint. So it's just going to depend. Unfortunately, hopefully it will work out for us. The state is defending that, trying to say that, well, you don't have to agree with this as an instructor. You could say anything, but that is, expressly contradicted by the terms of the law itself. But I guess we'll see.
Yeah, I think that's generally right. It's going to turn in significant part on sort of how viewpoint-based the enforcement of the law is going to be. So I think if, so for example, I have taught CLE courses before, and you have to submit them to the bar for approval. I think if the bar is approving or disapproving one viewpoint on that, that's more likely to trigger a meaningful First Amendment scrutiny. But
Caleb?
Listening to Caleb's talk, I was wondering what you thought about the idea that what if you were a member of a bar, such as a circuit bar, you became automatically members of all of the district courts within that circuit? Or if you're a member of the Supreme Court bar, you'd be a member of all of the federal court bars automatically?
Well, I guess that's interesting. I hadn't thought about that. I think it's still necessarily requiring some kind of an initial licensure, because at the Supreme Court bar, you can't even become a member for 3 years. And that could be a problem if you've got cases in the interim, especially if it's your original case that starts in a district court and you wind up at the Supreme Court. So I don't know. I think what makes the most sense to me is, since I'm just assuming we're not going to get rid of state legal licensure, I don't see that happening. Maybe, but I'm just going to assume that it's not. And so there will still be the requirement for attorneys to be licensed in a state. And so, since at least all of the district courts I've looked at, getting admitted there is just as simple as already being admitted in your state. If it's really that easy, basically just ministerial, to be admitted in your local federal district court, as soon as you have that, if the rules just change where you can go then at least get pro-hocked in any other district without needing local counsel approval, I think to me that's the easiest and the most direct way of doing it. Maybe you could scale that back even further and just say, well, you don't even have to get pro-hoc, just say, show you're admitted in one court. Now, maybe that's difficult from to get technical from a PACER filing standpoint, and they just have to create a fix for that. I mean, I guess good luck with fixing PACER, but just maybe there are some, on the margins ways to get at that. But I think what I'm really getting at is there should be the simplest approach to this would be what I would favor.
yeah, my thought on that, I think it's an interesting proposal. What strikes me, so I'm a member of many federal bars. I'm at the Courts of Appeals, I'm a member of everything except the First Circuit and the Federal Circuit. In fact, I have a little friendly competition with a colleague at IJ to see who can be a member of the most of them. And I just got admitted to the third, which brought me, I tied with him. Unfortunately, he's a member of the Federal Circuit from doing a patent case, and I'll never do a patent case. So, but one thing that strikes me is maybe it's not so much the notion that you get into this circuit and then you can practice in all the states, but a distinction between practice that is focused on federal law and practice that is focused on state law. So for example, the kinds of First Amendment cases that I litigate, I mean, in principle, the First Amendment means the same thing in every single state. Certainly we cite the same precedent everywhere we go. So the actual state that I'm practicing in is almost irrelevant, but for the fact that it's the sovereign that has enacted the law that I'm challenging. It's not responsible for any of the law really that I'm trying to apply, things like statutes of limitations and things like that. It may be an easier sell to try and relax the rules for people who have a federally focused practice as opposed to trying to do it more geographically.
Hello, thank you. So I have a question looking to British history and their legal profession. Are there, whether there are any lessons we can take from the solicitors? Because my understanding is you had the barristers who do all of what we would regard as the heavy-duty legal functions that should absolutely be licensed, like appearing in court and all that. Someone who was very qualified had to do that. And then the solicitors developed basically to fulfill the need that we're talking about, do all the stuff that the barristers didn't need to be doing. And as we know, they got to be more and more numerous and influential and even make more money than a lot of the barristers. So, but then my understanding is also that now they're as highly regulated as the barristers are. And so you have some of the same problems, and a number of panelists mentioned how there's an access to justice issue in Great Britain as well. So what lessons can we take from that, both on what to do now and potential challenges down the road with broadening the legal profession?
Yeah, so I think that's a great question. I'm not an expert on it, but I have spoken with some people who have worked on legal deregulation in the United Kingdom. The way the UK approaches the unauthorized practice of law is completely different from the way the United States does, because they do not apply it to pure legal advice. So if I wanted to, tomorrow, I could move to England or to Wales, I could hang out a shingle, and I could start giving legal advice on anything I wanted to. Someone would be a fool to pay me for it unless it concerned American constitutional law, but I could do that. And instead, the way the regulation of the practice of law works there is there are these 6 covered activities, and they include initiating litigation, right of appearance before courts, notarial activities, certain property transfer activities. I can't remember what all of them are. Interestingly, though, they kind of break down along this line that I was discussing between the things that lawyers do that are pure speech and the things that lawyers do that actually are either conduct or speech that occurs in a highly regulated government-created forum where the government has greater authority to regulate. I think the fact that it works that way is a great, again, example of a less restrictive alternative. And one of the arguments that we have put forth in our complaint in the North Carolina litigation is that this is the way it works in the United Kingdom, or at least England and Wales. I think Scotland is different. And because there is this less restrictive alternative, the government has a burden to show that it wouldn't work in North Carolina. So I do think it's very informative.
Yeah, and I'll add to that in terms of the UK reference. They in the UK and Australia, they've had non-lawyer ownerships at law firms. They've called them alternative business structures. They've been doing it for many years. But sometimes when we get in these debates, like we sort of forget about reality and the way things actually work at firms now in terms of, should a paralegal be licensed? Like at most estate planning firms, the paralegal is doing all the drafting and the attorney shows up at the signing. At most like plaintiffs' bankruptcy firms, the paralegal is doing a ton of the work and the attorney's not. And there's a lot of really successful bankruptcy and estate planning attorneys that run their practice that way, and the paralegal doesn't have any special license other than having a lot of experience as a paralegal. But in terms of the international reference, when I think about these things, I think about what's actually going on in the market now. Like there are plenty of really big international law firms. Like you have an office in Chicago and one in New York and one in Tokyo, and you may be working on a deal where your client's buying or selling a business in London, and everyone's working on the deal. So who's licensed where, and what paralegal is qualified to do what? So these things are happening on a daily basis at big firms like in the United States already. So I don't know that it's that, I don't know that we need to look to the UK to see like, hey, how do we navigate this? Because I think it really is already happening at the big firms. People just don't really talk about it at this level.
Question for Paul. Where does drafting of legal documents, do you think, fall on the speech conduct dichotomy, in that you are engaging in an act that is certainly speech. You're putting words on a page or filling in words on a form, but at the same time, those are being used to secure legal rights.
Yes, so, I do think that this can be a closer question, and it turns on the facts. To use the analogy of like a doctor's prescription, if the creation of the document itself is creating legal rights, then it seems to me that the courts are probably going to decide that that is a regulation of conduct and not a regulation of speech, because what they're interested in is the creation of those rights. But at the same time, go back to the How to Avoid Probate book, which is full of legal forms. I think probably those forms are essentially a form of advice. It's recommendation. Here is the type of form that will accomplish what you want to accomplish. So I think it's a little more fact-bound, and there can be situations where it's going to be a closer call. And I think part of it is going to turn on what's the understanding of the person who you are preparing the form for. Is it their understanding that they're going to take this and consider it as advice and then do their own thing? Or is it, here's the thing that's going to create the legal relationship you need? So that would be my answer.
Right, and just for a quick follow-up, I think that raises interesting issues in terms of software, where it's in many ways the same as the book, where you're saying, here's the legal advice, here's how you should fill these things out, here's the forms you would fill out, only it's taking that one extra step of completing that for you. But is that technological step enough to turn it from advice into, from speech into conduct?
Yeah, I think it's easy to overstate the distinction between books and software, because you can imagine a very detailed book that essentially has a flow chart that says, what's your situation? Or, kind of like the instructions when you fill out your taxes, right? Like the instructions are super long, and if you've got one situation, you skip to this step, and if you got another situation, you skip to this step. So you can imagine a book laying out those kinds of instructions for a legal situation. And I think everyone would agree under contemporary First Amendment doctrine that that's speech. If you've got a software program that is essentially doing the same thing, that same kind of checklist, I think that would similarly be treated like speech. And there is some precedent for this. The Institute for Justice, our first occupational speech case, was a case against the Commodities Futures Trading Commission, which was regulating people who wrote commodities trading newsletters and books, and also software, which sort of worked in this way. And we did get a district court ruling that this violated the First Amendment to require people to be registered commodities advisors in order to publish this sort of software.
Thank you. So, I have a question for the panel, and in a sentence, my question for all of you is the requirement of a bar exam to practice law escapable? And let me explain that question just a little bit, because I've heard two types of arguments when we talk about reforming the requirements for legal licensure. And one of those arguments, I typically hear it said in the context of CLE, which is CLE is a complete waste of time. I don't see any justification for CLE at all.
It's a complete scam.
It's a complete scam, right? So there's a slightly different argument, I think, that people make, and it's not quite as powerful an argument with respect to the requirement of a bar exam, which is, this is kind of lousy, and it doesn't quite test what we want to test, and it's really kind of a weak way of getting to where we want to go. It's kind of a means ends problem, and I think that that's not quite as powerful or dispositive an argument against the bar exam as the kind of arguments we could make against CLE. Pretty obviously, just about everywhere across the 50 states, you have to have a bar exam to practice, and with respect to this, and with respects to situations where you don't, such as when you get a law degree from certain schools, similar, there were sort of emergency requirements, emergency changes in the requirements during COVID, where you just had diploma privileges. I mean, that seems to me to be a kind of proxy for a bar exam. I'm wondering if y'all have any strong views as to whether we really have to have something like a bar exam, And it could be in conjunction not just with a law license, but with the kind of other credential certifications that you're talking about. So my question for all of you is the requirement of a bar exam or something like a bar exam escapable in our system, or is it just something that we really do need to have in order to have a strong and effective system of lawyers?
I mean, we're a free country. We don't have to have anything, and I think we could have a system that was not as reliant on the bar exam as it is. To me, I think the most sophisticated argument for the bar exam, and I don't find it to be a very compelling one, is that a client can come to you and they may have more legal problems than they realize. And when they tell you their legal problem, they think they have a problem that's about child custody, but in fact they have a problem that touches on all manner of other areas of state law. And unless you are well versed, or at least have some exposure to those areas of state law, you're not going to pick those up, and then you may advise them in a way that prejudices their rights. I mean, that's certainly possible. That could happen. I think that is based around a model of the practice of law that largely doesn't exist anymore, which is the person who graduates from law school and goes out and hangs out their shingle, and you come to them with your legal problems, and then they handle that entire legal problem. And very few lawyers do that nowadays. You know, you graduate law school, and typically you go to work for a firm where you are under the supervision of more experienced lawyers. You're probably not dealing directly with clients at all. And if you are, it's on pretty focused things under the supervision of these more experienced lawyers. So you could imagine a system where if you want to work unsupervised right out of law school, you have to prove that you have maybe this broader experience. But if you want to work for a firm where you're under somebody else's supervision, you don't. I could see that being a less restrictive alternative. But I could also see having a system of purely private credentialing where, you know, if you want the assurance that your thing has been viewed by a state licensed lawyer, then you go to someone who has voluntarily decided to take the state bar and prove that they have those credentials. But I do have to say, I mean, I share the view that other people have expressed that I think the bar exam tells you precisely nothing about someone's real world ability to practice law.
Can I push back on that for 1 second, Paul? I mean, it seems to me that the bar exam is in some respects not terribly different from, say, the kinds of tests that one might take to enter the armed forces. And I think in many jurisdictions, people have to take tests to join fire departments or police departments. And it seems to me that all of those tests, in various ways, are something like IQ tests. I mean, they're attempting to measure some kind of generalized mental aptitude. I guess I want to rephrase my question because I may not have put it in the best way. My question that I think you're responding to is really something more like, is it most socially appropriate to have something like an IQ test or a test that, as a psychometrician say, measures G with respect to the practice of law, with respect to letting people into this realm, or is that something that in the best world is really escapable?
Well, I mean, I have to say, I think I've known too many lawyers to believe that the bar exam is an accurate measure of G. Yeah, I'm very skeptical of that argument, and it seems in particular, I mean, in a way, law school admission and the LSAT is a similar test. Mm-hmm. And if you get through that and get into law school and then get through law school, it's not clear to me that the additional information provided by passing the bar is that much more probative of your general intelligence. And it certainly seems like a blunt tool for that. And, you know, as a libertarian, I am skeptical of occupational licensing. Generally, I think that the market can generally sort this out. And if people did want to have a system of private credentialing where, hey, you know, you only get our A+ ultra great certification if you prove that you're a super duper really bright lawyer, you know, people could advertise that. And I think it's actually interesting that state bars have traditionally been very hostile to people advertising these kinds of special credentials. You know, that you're like a certified trial specialist or things like that. And it has taken First Amendment litigation to protect the right of people to include those kinds of private credentials in their advertising.
Caleb, I didn't mean to cut you off.
Could I just add on to Paul's Steelman, as basically the bar exam is a good opportunity to show off your ability to issue spot. I don't know if that's even really true so much anymore, as I think a lot of the MBE and even other states' bar exams themselves are going to multiple choice, so they're decreasing perhaps the number of essays where you would be able to have the opportunity to demonstrate that. But I think that's really most appropriate for law school itself through exams, so being able to do, that's what professors do with their exams, is give you the opportunity to issue spot. But to your question, is the bar exam inescapable? I think thanks to public choice theory, probably yes. We're probably in the minority in this room of lawyers willing to really challenge the status quo. Unless we have a way to really show the public and legislatures that, look, this is actually not benefiting anyone, and get the public on board, I don't really see a realistic path to that on any large scale, but that's just my limited view.
Yeah, in terms of the question of whether there should be a test, my selfish, knee-jerk, unsupportable response is, well, I had to take it, so you're going to have to take it. And that's how most lawyers feel. But I think if in lieu of an exam, which, by the way, if you gave legal advice under those conditions, it would be malpractice. If a client came to you with a fact pattern and said, I need an answer in 30 minutes, and it better be right. No one would ever practice law that way. But I think in lieu of an exam, if you had law school component combined with an apprenticeship, I think it would result in a more qualified, prepared legal profession. And so I would be way more in favor of an apprenticeship in lieu of an IQ test.
If I can just add one thing very quickly. So I'm a member of the Virginia Bar, and Virginia is notorious for the conditions under which it administers its bar exam, which is that people taking the exam have to wear a suit. You have to show up and wear a suit, although they also ask you to wear tennis shoes so that if you get up and walk around, your shoes aren't clip-clopping and bothering people. And to me, that is somewhat of almost an admission that this is really kind of a hazing ritual for people to show that they're sufficiently serious about entering the practice of law, as opposed to an actual diagnostic measure of their ability to practice law.
Well, on that note, thank you very much, and will you take us out then?
Absolutely. Well, please join me in thanking this fantastic panel. And I wanted to thank all the participants as well as the audience for tuning in on this very important issue of legal licensing reform. Does the world need more lawyers? And for more content like this, please check out regproject.org. That's regproject.org. Thank you very much.